All right, welcome back to TuckerAllen Live on Facebook. I'm your moderator for this Friday. I'm Scott Trout and joined by TuckerAllen attorney Jim Gau. Welcome back, Jim.
Thanks a lot, Scott.
Happy Friday. And let's just let everyone know that may be watching live or recorded, grab a piece of paper and a pen because you want to take notes. I was just telling Jim off camera that he's going to teach me quite a bit about Medicaid and Medicaid planning today because I don't know anything about it and I want to learn all about it. And there's going to get some technical numbers here quite a bit. So get ready because in the next few minutes, we're going to go through quite a bit for you as you think about Medicaid. And that's part of the job that TuckerAllen does is not only just trusts and wills, but Medicaid and planning and explaining the intricacies of these numbers. Really interesting. So, okay, let's get going. But before that, if you have any questions, you can go to TuckerAllen.com. You can check it out. You can schedule an appointment virtually, on the phone, in person. They have offices throughout in St. Louis metro area, in Illinois, and up in Kansas City metro area as well. You can just schedule an appointment right off of the website. So you don't even need to talk to a human being. You can do it right there. So, but all right, Jim, let's get right to it, Medicaid. So let's go through, I guess there are some Medicaid numbers, right, that allow, or allowances. And I'll have you kind of go through that. I know a lot of people probably that are thinking about it, contemplating it, maybe generally familiar, and they're going to want to know what the allowances are so they know whether or not they can qualify or what they need to do, and then we'll get into assets. So kind of fire away with Missouri, what the allowances are in Missouri for Medicaid.
Sure. So basically, to qualify as an individual for Medicaid in the state of Missouri, you have to have less than $5,035. I don't know where the 35 came from, but it was around 5,000, which was easy to remember, but they've increased it to 5,035 here just recently in July. And then for a couple, it's just double that. So if both spouses are in the nursing home, then it's 10,070. So just double the individual. Now the rules are different if one spouse is in the nursing home and one is still staying at home, and they call them the community spouse. So the maximum community spouse resource allowance in the state of Missouri is $130,380. So that means the person in the nursing home, they use all of their income and basically transfer all their assets to the community spouse, which then can keep up to $130,380. Now that's the maximum. It's a range, and there's a way of figuring out. Missouri just takes the total assets, divides it by half, and then the maximum amount is 130,000. The minimum amount's a different, lower number, but we try and get as close as we can to that 130. And then the community spouse that's staying at home gets to, so we can actually convert some countable hard assets to an income stream. And usually that's through the use of a Medicaid compliant annuity. And so the maximum income amount that a community spouse can keep is $3,260.
And I think we talked about that at one point about they get this income stream by staying at home to care for themselves, which I think is really interesting. So when you talk about this allowance, that's just the total assets that they can have in order to qualify. Is that what that means? Or just using that word?
So total countable assets. So there are some exempt assets. For example, your personal residence is exempt. So they won't count that when they're determining your eligibility. But if there's no one living in it and both spouses are in the nursing home, or we're just dealing with a single individual, they can put a lien on that property, on that real estate, unless some advanced planning is done. And normally that's either with a irrevocable trust that we can put the home into, but it's got to be timed properly. And then we've got to determine whether or not the penalty period is going to be too onerous and, we can't use it. Or we can do what's called a remainder interest deed, which gives normally children the remainder interest. So the parent keeps a life estate, being able to use the property for the rest of their lives. And then we can give what's called a remainder interest to the kids. And because they own a future interest in the property, it prevents the state from basically putting a lien on that property.
Got it. All right. Before we get to those other assets, what about Illinois? Do they have a similar allowance mechanism in terms of trying to figure out the assets?
Yeah, as many of us that live in Missouri can probably attest to and guess, the limits are lower in Illinois. It's a little stricter. So that individual resource allowance in Illinois is $2,000. It's $3,000 for a couple, so they don't double it. They just add another $1,000. And then the maximum community spouse they can keep their allowance is $109,560, which is lower than the $133,880 in Missouri. And then that monthly income amounts $2,739 in Illinois.
Wow. So there's some work to do. I mean, goodness, for a couple to have $3,000 in accountable assets. I mean, it's the whole point of having someone like you try to give them some planning and ideas. So as you know, everyone's writing down the number, and we talked about the personal residence, and I know you and I've talked about maybe it was Kevin, about having a child living with you who's caring for you, or you employ them in the house and you can give them, reasonable salary or whatever it may be. Is that offset as well?
Yeah. So if you have, and we've had some clients recently actually that have had children caring for them in the home. So if a child lives in the home with a parent and is caring for them, the state kind of looks at that as, oh, well, we would have been paying for Medicaid and nursing home costs for that person much sooner had this child not been around. So as long as that child has been living for 2 years, at least 2 years in the house with the parent caring for them, then the parent can transfer that house to that child without imposing any kind of penalty. So it's a great way to protect the house, but obviously, 2 years, we have to plan ahead kind of for that.
And so I know it's a question for me is living in the house, is that 51%, 50.1%? Do they have a quantification in terms of what qualifies?
So we normally want that to be their primary residence. And so they should get, usually the evidence we use to show is pieces of mail coming in their name to that house, their driver's license, where they're registered to vote, things like that. Yeah.
Okay, good. All right. So checking accounts, cash accounts, securities, retirements, what else?
So cash accounts not exempt. The only exempt assets really are the primary residence, one vehicle, life insurance, cash value up to a certain amount, and then the death benefits obviously are exempt. Prepaid funeral up to $15,000 normally is the limit on that, so you can prepay your funeral. And then personal belongings, obviously, I think the family Bible is always listed in that list of personal belongings and jewelry and things like that aren't crazy valuable. But yeah, cash accounts are kind of, the big thing that people worry about is we've got this giant, stack of cash or savings account or investments that we don't want to, be spent down before the state will kick in. We want it to go to our kids. We saved our whole lives for this. And so those are easy to kind of plan for because they're easily movable. They're post-tax money. They've already been taxed, unlike retirement accounts. But the issue is once you kind of do some planning to protect it, you have to give up access to it, direct access at least. And so that's hard for people if you don't have, a giant store of cash, a giant savings account. It's tough to give up access to the money that you're kind of counting on living on day to day. And so planning on those. We can always use the cash accounts. I mentioned countable versus non-countable assets. So like if the house needs a new roof, we use the cash accounts to buy that roof. If there's outstanding medical expenses or something, we can use that to pay down, whether that be from a retirement account or a cash account. So converting non-countable to countable, or countable to non-countable rather, is really important in Medicaid planning.
So, if they've got someone, they're taking their notes here, that's the question is what are their options when you're planning? They're thinking, okay, I'm over this threshold. What do I do in order to get there? What are some of the things that they can do? Obviously, no doubt, we talk about this, that everyone's circumstances and facts are different. So we can't give legal advice and we can't really tell them, they shouldn't be taking this as gospel, but this is the direction and really meant to have and spur a conversation about, hey, I was listening to Jim Gau about TuckerAllen and he said I can do X, Y, and Z. What do you think? Give me some advice. So kind of give them the direction.
Yeah, so normally we look at, obviously the first strategy and a planning strategy that you don't necessarily even need an attorney for is just simply pay for the nursing home until you're out of money. That's, the default plan, if you think about it, is to just spend your money on the nursing home until you do qualify and get down to those allowance numbers. And then normally once you get down there, the nursing homes have a social worker. They can help you fill out the application. Again, no attorney really necessary for that, but you're spending all your money down. And so that's the downside. We didn't have to talk to a lawyer, but we're broke now. So that's obviously the first option. The second option is advanced planning. So planning 4, 5, 6 years in advance and usually that's going to include irrevocable trusts. And so the target audience for that are people between 500,000 and 2 million. So you've got enough money saved that you don't, there's probably an investment account possibly or something, or in the house that we can protect that you don't need liquid day-to-day access to. And so you can still get access through your kids or through your beneficiaries, whoever they may be, but you have to give up direct access. And I say 5 years in advance, 4, 5, 6 years in advance, because that's the look back for Medicaid. So once we gift to an irrevocable trust for this advanced planning, the clock starts ticking. And so once we get to 60 months after the date of that gift, Medicaid, it's not your money anymore as far as they're concerned. And so that'll get you below the threshold. Obviously, we're holding some money out. And then the third, situation that we run into is crisis planning. And unfortunately, this is kind of the most common is, somebody, mom, dad fell and broke their hip. They're now in rehab and they're going to have to go into a nursing home. They can never come back home. So obviously we don't have 5 years in that scenario to plan ahead. But we can still normally with through an attorney, you can protect, normally it's up to close to a half of your assets, just depending. Obviously it's a case by case basis, but we can normally do, run an equation and figure out if we gift this much, what's the penalty and how much do we need to cover that penalty? And normally, like I said, we can cover about half, protect about half.
Yeah, it is interesting because I'm always interested in this topic, in terms of just general estate and wills and elder. I talk to other people and they're like, well, yeah, I don't do kind of this type of planning. It's complicated. And so there are people, and you guys are competent to do it, and you do it, right?
Yeah, absolutely. And it is, these are specialized trusts. You don't want to just you can't print a legal Zoom form off the internet and expect it to work under scrutiny from the state of Missouri or Illinois.
Right. Yeah.
This is definitely intricate planning, complex planning, and the terms have to be very specific to actually qualify to protect your assets.
And I know you mentioned 60 months, and I guess, is there a way, as you think through people, we encourage them to start planning early, not just for Medicaid, but obviously for estate planning? I mean, can they start positioning their assets and in whatever they're designing, whether through irrevocable trust early in their life, maybe in their 50s and they're not sick and they don't have to necessarily be thinking about long-term care? Is that something that you the evolution of an estate plan over time?
Yeah. And so I always say, this is the Medicaid planning that we do is an offshoot of asset protection planning. And so everybody thinks of asset protection planning as, oh, this is protecting me against a lawsuit, but it's very similar planning to Medicaid planning. And I always say the first step in asset protection is just get adequate insurance. So looking into long-term care insurance when you're younger and it's potentially not as expensive, that's always the first thing that people kind of do. And as you're thinking about that and talking about long-term care insurance, go see your attorney and see if there's something that they can do to protect even more assets, or we can leverage that long-term care policy as part of the irrevocable trust planning. So if we know we've got 3 years that a long-term care policy will cover, we can plan for the 2 years that you have to fill up that 60-month look back. So there's a lot of combinations of things that come into play when we talk about this kind of stuff. And it really is just such a case-by-case basis that you should come in and sit down for a consult.
It is. And again, I know we say it all the time in these live events, and where we talk about, the collaboration between a financial advisor who may be able to help you secure a long-term care plan. I met with a financial advisor and he talked about it. He goes, yeah, I work with estate planning attorneys all the time as we try to combine, our resources together to put a plan that makes sense, as you just suggested. And I think that's what people should be doing is, hey, I have a financial advisor. I want to get my attorney and advisor on the phone. I'm sure that's something you guys do frequently.
Yeah. And not only so, you've got your attorney, but the attorney's not the end all be all as much as we think we may be. We need a financial advisor in the mix. We need a CPA, an accountant that knows, what your tax situation is personally and individually, so that we're not screwing something up and making you, putting you in a higher tax bracket or setting this trust up. We want to make sure that the trust gets taxed at your individual lower rate rather than the federal trust rate. And so, things like that, obviously, and then just liquidating accounts like retirement accounts and things like that, that's in the financial advisor's wheelhouse. So it really is a collaboration between an attorney, financial advisor, and an accountant.
Great. All right, Jim. Well, thanks. I know it's a lot that we just crammed into the last 15 minutes. So if you have any questions, though, Jim, certainly he knows it. And we want to get you a call and a consultation. So thanks, Jim, for joining today. Appreciate it.
Yeah, no problem.
So check them out, TuckerAllen.com. Obviously, not just for Will's Trust, but if you have questions about Medicaid planning, you just want to get more information, set up that consultation. You can do it just like this on Zoom, on WebEx, virtually, however you want, in person, on the phone. It's certainly worth the time to educate. Just like anything, we go to Google, but he said, that online form is just not going to do it. It's not going to cut it. It's complicated. So every Friday, 1 o'clock Central Time, bring you information just like this to kind of give you the direction you need to have a consultation with someone who focuses exclusively in areas just like this. So until next Friday, have a great weekend.